Somerville Court of Criminal Appeals is now back in session. You may be seated.
All right, call the next case, please.
Christopher David Hodge versus State of Tennessee.
Good morning, Your Honor.
Good morning.
Good morning, my friend on the website as well. Your Honor, I would reserve 5 minutes for rebuttal in this matter. Would Your Honors care for me to give a brief recitation of the facts or go straight into the argument?
Well, if you want to go in the argument, explain how this is newly discovered evidence of actual innocence.
Certainly.
If you really want to hit the point, that's
Certainly, we'll hit the
case.
point straight on the head. If Your Honor will recall, this direct appeal in this case, State of Tennessee versus Christopher David Hodge, that was an appeal in which Mr. Hodge challenged the result of his original trial because the court refused to grant his motion to compel evidence of the alleged victim's prior inmate and criminal record. And they said that was error by the trial court, but it is harmless because of testimony from Dr. O.C. Smith, who alleged that basically the manner in which the alleged victim died was indicative of murder. So 20 years later, Mr. Hodge gets with me, and we stumble across evidence, some articles, newspaper articles, and a background check, that he was federally prosecuted for faking a bomb threat. And I guess during the course of the investigation, they found that he had some kind of mental conditions. I guess he craved attention, had a penchant for dishonesty. That's not my words, that's theirs. And that he just had a lot of problems with him. So they prosecuted him. Mr. Hodge did not know about this information at the time. He did not know about this information at the time because he's an inmate at the prison, West Tennessee State Penitentiary. And that's my basis for saying it's newly discovered evidence, because he didn't have access to that information, and we found out the information well after the fact. And since that was the only reason, appears this court didn't give him a new trial on the original appeal because of his testimony, I would make the case that had we had that evidence at that time, it might have been a different story. The outcome would have been different. That at the trial, Mr. Hodge alleged that this is a self-defense case. He alleged he's innocent. He didn't do it. O.C. Smith's testimony is the only testimony there that convinced this court not to give him a new trial.
So, Mr. Murphy, you raise an equivocation in your statement.
Certainly, if you could elaborate.
Cleverly. You say the result might have been different.
Well,
so how about this? Is it possible, just is it possible, that the original jury, had they known that he was being federally investigated for bombing attacks or as it was, is it possible that the jury nevertheless still could have found him to be credible as to the nature and cause of the death?
I would submit no.
As a matter of law, it could not have happened?
Let me tell you, well, let me submit this.
Is it possible?
You use the word possible. It is possible.
All right.
Is
so
it probable?
Well, okay.
Sorry,
but
I'm sorry.
No. And you're being a very effective advocate today, candidly. If it is possible that could happen, doesn't that necessarily give up the ghost? Because clarity requires, I think, in this situation, proof that the petitioner is actually innocent. And if it is possible, the jury still could have found the medical examiner credible, knowing everything there. I think by definition, that's not proof of actual innocence.
So, Your Honor, if I might pull the excerpt.
Even if it's probable they wouldn't have? If it's still possible that they could have, that's not proof of actual innocence.
If I'm understanding you correct, you're saying that if it's possible they could have found them, that's not proof of actual innocence. As in, it's this court's or Your Honor's position that it has to be 100% proof.
It's not my position. I'm trying to probe what actual innocence means here in this case. So
yes.
If it is still possible that the jury could have credited the medical examiner's testimony, even knowing the other impeachment evidence, if that is still possible, how is this proof of actual innocence?
Well, Your Honor, I think clarity is requiring that, let's see, I think it's clear and convincing that the petitioner is actually innocent. And so I think when I think of possible, I think of like, maybe there's let's say, it's possible that, I don't know, you could win the lottery at this very moment. Unlikely, really unlikely, but
I mean, I think if you were to come into the court and say, as a matter of law, the medical examiner's testimony was not credible, that no reasonable jury construing facts in the light most favorable to the state could possibly have found him to be credible. I think if that's the argument, you may get closer maybe to an actual innocent standard, but once we concede that it's at least possible, the jury considering the impeachment evidence nevertheless still could have found him to be credible, help me understand how that's proof of actual innocence.
well, I think that's
So that we get to due process tolling.
certainly, and I think what I am alleging is what you just said, no reasonable jury would make that determination.
So you're saying that considering that impeachment evidence, the medical examiner's testimony was not credible as a matter of law?
And in the sense that no reasonable jury reached that conclusion, yes.
Okay.
Because that's the only witness they presented for that, and he had some serious issues with his credibility, given that he was federally prosecuted right after that, and they didn't
Not
just...
convicted.
Not convicted. I don't fully know all the details or I guess what happened with that case. I'm not sure if I put it in the record or not. But what happened with that case is it resulted in a mistrial, and I guess they didn't take it up afterwards. But that's a much higher standard of proof beyond reasonable doubt for that doctor. Regardless of what happened with that trial, that's some material, and I would say even perhaps exculpable information, which Mr. Hodge ought to have been appraised of, and had he had in his possession, he certainly wouldn't want to use that, given that this was their sole witness as to his sole direct witness as to his guilt. There was no one else in that cell there besides him and the alleged victim himself. And so they got to use someone else, and there's someone else was O.C. Smith. That's what this court noted, and why they did not reverse and remand this case originally in 2004.
Well, he also testified that he basically choked him without intent to kill him 4 times, and then the guy died.
Yes.
And that he was also acting in self-defense, even though he was 6 foot whatever, and the other guy was 5'7", 135 pounds, whatever. I don't have my notes right now.
Yes.
But that was all testified to.
Yes.
And the jury heard all that. They also had the bed sheet strip that Dr. Smith said was the ligature that was used to choke him, and there was physical evidence that he testified from that bed sheet, correct?
Yes.
So besides just Dr. Smith's testimony, there was evidence from the defendant how he thought the person died. There was a 15-minute window in which this whole thing could have happened, correct?
Yes.
And, all that circumstantial evidence, the size of the victim, the size of the defendant, the marks on his neck.
Yes.
All of that's evidence in addition to what Dr. Smith testified to.
Certainly is, but I think this court made it a point that it wasn't really all that other stuff, but simply Dr. O.C. Smith, what he averred to that jury, which caused them which caused them to rule that the error committed by the trial court in the first place was harmless. Yes, there was a testimony about a bed sheet, and there was testimony from, I guess, Mr. Hodge about how he choked him 4 times, but there was also testimony how the alleged victim here was talking to himself, talking to TVs, had some kind of clearly issues there, I guess. It wasn't like it was just a pretty straightforward case. Their whole case hinged on Dr. O.C. Smith, and I guess his investigation and summary of what happened as far as to get a conviction. And so my contention here, if your honors will believe me, if your honors will agree with me that Dr. O.C. Smith is the linchpin in this case, if we have evidence showing that he was not credible at that time, and not just credible in a light sense, I mean dangerously not credible, I think we should certainly be allowed to at least present that to the trial court. Let the trial court consider it, and if they determine, based on whatever we find from the Shelby County Government's office, they determine that there's nothing there, then fine, court can drop that. But we didn't even get that far.
How does this show that Dr. Smith is not credible concerning the testimony that he gave at trial?
And I guess that's the problem I have.
Specifically as to the nature and cause of death. So not even talking about other issues, but as, to add on to Judge Holloway's question, how is he not credible specifically as to the nature and cause of death?
I can't comment on how he's not credible specifically to nature and cause of death, other than what I found, which is the conclusions, I guess, the federal investigation reached about him in general. I certainly would be able to comment on that
Were
further.
those allegations by the DA, or were they found into by the court?
These were allegations by the DA. They
Right.
weren't findings by the court because that trial went to a jury. Nevertheless, all I seek to do here, Your Honors, is get the information in the first place. I indicated in the petition that, hey, the Shelby County government, they won't give me this stuff. Let me just subpoena that, take a look at it, have a hearing, trial court can decide it. And I would be in a much better position to determine whether or not, fully, if in fact Dr. O.C. Smith is acting consistent with what the federal investigation found. But because I can't get to that stage, subpoena that information, I'm limited to what I found without the subpoena power. None.
So help me with this, counsel. Let's say that you have established actual innocence under Clardy. You get by the statute of limitations issue, and now we're considering quorum nobis on its merits.
Yes.
Typically, quorum nobis does not have as a basis for assertion the claim that a witness was not credible at trial. So typically with quorum nobis, if the newly discovered evidence is only related to the credibility of a witness, typically that's not enough to get you over the finish line on the merits of quorum nobis. How is this case different than that?
I think because this case is such that Dr. O.C. Smith is essentially the only witness pointing towards guilt for Mr. Hodge here. I think, Your Honor, if Your Honor humor me, if in fact we had a case that was solely one witness's testimony, let's say the classic assault case, he hit me, and then years later we find out that the victim had some kind of psychosis or whatever, would Your Honor's position be that even though we found this evidence out after the fact, that because that merely deals with credibility, that's not enough to survive the quorum nobis threshold?
Well, I wonder kind of in this case, I mean, my understanding was that the petitioner admitted at trial
Yes,
that he had killed the victim.
he did.
And the only question then was with respect to, was it self-defense or not self-defense? Is that right?
That's correct.
All right, so we have the evidence here that the defendant has caused the death of the victim
Yes.
by the petitioner's own admission and by the other evidence that Judge Holloway gives. And so if the jury, petitioner, I believe, testified at the original trial, is
He
that
did.
right? So if the jury disbelieved the petitioner at the original trial, there goes the self-defense issue. It seems to me, once again, we're just back talking about the credibility of a state witness, and on its merits, I wonder if quorum nobis allows that.
Only because that is essentially their case there. I don't know if that's why this court came back and they pointed to his testimony when they said, we're not going to reverse remand because this error is harmless because of what Dr. O.C. Smith testified to. And so I think, yeah, in a general case where the case is more developed, we have lots of things to look to. No, credibility would not be enough, and rightfully so, we should lose. This would be a waste. I wouldn't have even entertained this petition. But given that their whole case, essentially Dr. O.C. Smith, with circumstantial evidence, I guess, with my client being bigger than him and whatnot, I think it's a little different than it would be the usual case of, this person's not credible, I don't believe him. This person is the case. And so I think we have to take that into account.
Okay.
And if Your Honors have no other questions at this time, I will sit down.
Thank you, Mr. Murphy. All right.
Oh, I'm sorry. My apologies.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the dismissal of the petition for writ of error quorum nobis because the trial court found two bases for dismissal properly. First, it found that the untimely petition did not warrant tolling because it didn't establish evidence of actual innocence. And second, going to the merits, it found that the petitioner had not stated a meritorious claim, even if tolling were somehow warranted. I'll take those sort of in order. Everyone here concedes that the petition was untimely. It was filed approximately 20 years after the judgment became final, so it's untimely, and per Clardy, the only basis for tolling that statute of limitation is proof of actual innocence. And I think it's important to get to what Clardy said sort of actual innocence was and what the defendant would have to prove. It talks about how we should assume the veracity of the new evidence and consider whether it would, if credited, clearly and convincingly show that the petitioner did not commit the crime. It would have to, in other words, quote, leave no serious or substantial doubt about the correctness of the conclusions drawn from the evidence. And here what we have is, at best, impeachment evidence. This is not proof of actual innocence. To your point, Judge Holloway, there was an abundance of proof establishing the defendant's guilt. First and foremost, he confessed. He admitted that he choked the victim to death. And while he claimed self-defense, that admission is incredibly damning. On top of that, we have proof that officers found I believe you said a bed sheet, found a ligature device that was used to strangle the victim, and the medical examiner testified that that was consistent with the cause of death. Being able to impeach the medical examiner doesn't establish actual innocence, and that's just the be-all, end-all. So the trial court and this court can just uphold the dismissal based solely on the lack of tolling. But even if it wanted to go further, could also uphold the dismissal because the petitioner has not stated a meritorious claim. And I don't even know if we get to the underlying facts, because for the writ of error coram nobis, it's talking about newly discovered evidence, and that's a term of art. And for something to qualify as newly discovered evidence, it has to meet certain parameters, which this evidence does not. First, the information has to exist and be discoverable at the time of trial. And my understanding of the petition hinged mostly on the federal trial itself and information that allegedly came out at the trial. That trial was 2 years after the defendant's trial. So that evidence did not exist at the time of his trial, could not have been presented. It does not meet that standard.
I thought he was alleging, though, that it was something more than just the trial, but it was the investigation itself.
So I think part of it tangentially mentions that he was under investigation at the time of trial. There's nothing in the petition and nothing that I've been able to find that establishes that that was somehow discoverable or obtainable, even with due diligence, that federal investigators would have somehow let defense counsel know we are currently investigating someone. So the state would submit that that doesn't meet the existing and discoverable at the time. The next prong is that the proof has to be admissible, and the state's position here is that it's inadmissible to the extent that the only thing that could have maybe come in is this investigation that's highly prejudicial and has minimal probative value. The defendant hasn't established that it would come in. And third, the defendant has to establish that it's credible proof of his claims, and he didn't attach anything to his petition to establish that, to meet his burden of proving that this was newly discovered evidence. And finally, to be newly discovered evidence, the defendant has to show that the information could not have been discovered in a more timely manner. I believe my friend on the other side here referenced that this information was discovered from newspaper articles. Respectfully, Your Honors, this very easily could have been discovered, years ago.
I mean, newspaper articles from 2005.
Correct.
Right.
So the defendant could have discovered those from 2005, could have done exactly what he did now. Even if he's in prison, again, there are resources, there's no proof.
Well, he's filed other post-conviction petitions as well. So he filed a post-conviction petition itself under the Post-Conviction Procedure Act. He filed for writ of habeas corpus. There may have been a third one that I'm not recalling, but he's had other opportunities to have investigations done.
Yes, Your Honor. He's had a lengthy procedural history with this court, and I believe maybe with the federal court as well. That's in the brief. So he's had the opportunity. So he hasn't alleged actual innocence with this evidence. So tolling is not warranted. Even if tolling were warranted, the information that is being alleged doesn't qualify as newly discovered evidence. So this court can really pick which way it wants to affirm the dismissal, but the trial court properly dismissed the petition. This court doesn't have any other questions. We respectfully ask that you affirm. Thank you.
I'd like to just touch base on a couple of things. First and foremost, with respect to investigative ability, as you know, in post-conviction, we don't get, I guess, was it Rule 13 investigators for anything after trial or anything. And so I think he would have been he wouldn't have had necessarily the same ability to find out information and facts as he would have been at his original proceedings on his post-conviction matters. Furthermore, I would make the point that the mere fact that he has filed post-conviction petition, habeas corpus motions and whatnot indicates that this isn't just some lazy petitioner. This is someone who is exercising every tool in his toolbox to try and reverse this original conviction. So I think we can credibly conclude that this isn't just a lack of due diligence here. This is an inmate who, not until I got on board that he suddenly may come up with this argument. I don't think he knew about it. And unfortunately, when you're in the jail, you don't have free access. Well, I guess you wouldn't have 100% free access to all the resources we have out here. And I guess that would include internet mainly. Here's what I see this case comes down to. If your honors are of the position that if the allegations in our petition are 100%, even if they're 100% true, then we don't prevail, then that's a conclusion you can render. However, if in fact the issue is, I guess, as Mr. Coleman is indicating, that, you know, we haven't really shown how it's admissible, credible, and whatnot, I think there's a really simple solution to that. As we've alleged in this case, we just wanted to subpoena these records in the first place, see what they are, put them before the trial court, and, you know, let the trial court decide from there. And so if there's any possible way, your honors of the mindset that maybe if these allegations in the petition are true, then it's worthwhile, I would encourage your honors simply remand this case, direct the trial court to allow me to subpoena these records from these government agencies, and let the trial court take a look at it, and we'll have a full and fair hearing on this. And that would be my position.
Let me ask you this, and I've been thinking about, you know, your argument. Let's forget Dr. Smith's testimony.
Okay.
Act like it didn't happen.
Yes.
The jury would have known that your client was in a segregated cell because he objected to being in with some other cellmate.
Yes.
So he was in this section by himself. There was a prison riot, and they brought in all these new prisoners and started shuffling them in cells, and they put this guy in the cell with your client.
Yes.
And they had some problems. They had a shower break, and he allegedly told the guards about the problem. He comes back, and within a period of 15 minutes, this victim, who's much smaller than the defendant, is choked to death, and the defendant says he acted in self-defense. I mean, even without Dr. Smith, there seems to be sufficient evidence for a jury to convict the defendant.
Would Your Honor agree with me that that sufficient evidence analysis should be coupled with the trial court? With all due respect to the trial court, I don't put anybody under the bus, but the trial court not erring and not allowing Mr. Hodge to recover records of this inmate's victim's prior records. Because if that's the case, then I guess as they're alleging in that original appeal, now we have evidence that the alleged victim was an aggressor because I guess he wanted to get these records to show that he's violent.
I just still don't see how Dr. Smith's problems, if he had problems, I know
Right.
he was investigated and not convicted, is sufficient to prove that the defendant is not guilty of the offense.
Right. I mean, that's about my analysis here, that I think Your Honor should look at it from this perspective. If we erase Dr. Smith, what still happens on it? And my contention is that without Dr. Smith, there's no evidence of this 4 minutes of choking him. There's simply my client's word that he acted in self-defense with some circumstantial evidence state used to try and say that he's definitely the aggressor. But I appreciate Your Honors allowing me to speak before you, and I appreciate your time. Thank you very much.
Thank you, Mr. Murphy. Thank you.
All right. Anything before we break? All right, we'll take a lunch break and be back at 1:30.
All right.